file victims to be able to sue corporate defendants who are alleged to be complicit in their victimization. I don't know if the gentleman from Kentucky would want to add to that.
Would the gentleman yield?
I would.
Yeah, I think it encompasses, it started out as an IP bill, and then I think to hide the nature of it being an IP bill, it was broadened in hopes of broadening the constituency of corporations who would be interested in this bill. And but what has happened is it has also broadened, I think, the constituency of people who should oppose this bill. The Davids, not the Goliaths, which could include people who've been harmed, for instance, by pesticides, or people who've been sexually abused or trafficked. And if I may take a few more seconds to talk about the bill's sponsor, his opposition to my amendment, he said that it's not fair that the defendant has to disclose the number of products sold or things like that. Well, that is material to the lawsuit. What is not material to the lawsuit is how you borrowed your way into court in order to hire that lawyer to get there. That is not material to the case. And so that would be my rebuttal to, it's not fair that the big corporation has to say how many times they stole the patent in order to determine the outcome of that trial. And I yield back to, that was Mr. Raskin's point that I'm reiterating, but I yield back to Mr. Johnson.
Will the gentleman yield?
To the gentleman from Florida.
I was listening to your passionate testimony. I wanted to hear a little bit more about the fat cats, if I could. Just a little more elaboration about the tassels and the briefcases. Like how gigantic are these fat cats?
These are real big folks. They're huge, as a matter of fact, huge.
Would the gentleman yield?
Yes, I would.
So at what weight can I get this bill through? You know, at 160 pounds, 140 pounds. I do have a question for the gentleman, though. If the defendant is a small business, do they get to use this? You know, you've mentioned large businesses, but how do you feel if it's a qualified small business against a large one? Well, should they be able to use this bill?
I think the playing field is as level as it can be at this particular time, though it's not level enough. And this legislation will tilt it even more in an unbalanced direction. So that's why I oppose this legislation.
The gentleman expired. The gentleman from California is recognized.
Thank you, Mr. Chair.
Wait, excuse me. I'm sorry, Kevin.
Oh.
I got to go in the order. I need to go in order. The gentleman from Wisconsin, then we'll come to the gentleman from California.
Yeah, Mr. Chairman, just a quick comment. I mean, to me, the reason I was attracted to the bill or thought the bill made good sense is because the legal system is being skewed. That the system is being leveraged by outside dollars. It's that simple. There's money coming in from the outside that quite honestly, I'm not sure how you can justify that. And eventually, the $18 billion that's being used to skew the system makes no sense. And I think the amendment makes the case. Because what you're saying is, yes, let's get these foreign governments out of this particular discussion. Let's make sure that we somehow carve that piece out and say, yes, that's justified. You know, I get it. It's part of the security piece. But you're admitting basically that the system is skewed. That right now we've got outside dollars coming in that no one knows where it's coming in. And in some instances, it's already been proven it's there to leverage and sometimes to gain damages. So, I mean, maybe this amendment narrows it, but it also makes the case, I think, that the system's broke. It's broke right now. And if that number of 18 billion continues to escalate, we'll just be back here in the next Congress doing it again. Because it's not working the way it's set up right now. It's just not working. And you can talk about the little guy, but you know, at the end of the day, the client is not in control of their own cases anymore. Yeah. They're just not. They're not in control of it. Somebody's out there shopping for outside dollars to fund these. And that's why I think we're just going to be back here next Congress doing the same thing.
Will the gentleman yield for a question?
Sure.
So I appreciate that you're bringing our attention to what are the systemic effects of this. But when you say it skews the system, I wonder if you could be more specific about that. I mean, say my community is a victim of some kind of environmental harm, and we decide to go to court to try to vindicate our rights and to sue to stop the harm. Tell me how our getting third-party funding from any particular source will alter the course of the litigation or the integrity of the proceedings when the court has to make sure it's deciding on the facts, on the evidence, and based on the law.
Well, I don't know how TPLF kind of makes a difference necessarily in that scenario, other than the relationship between, you know, the person that's engaged in a lawsuit, and suddenly they're making decisions about where they should go with that lawsuit based on dollars that clearly are leveraged, so that when the case is settled, there's going to be a windfall.
Would the gentleman yield?
That's what's going on right now.
Would the gentleman
That's
yield?
what's going on. Yes.
Yes, I might further your comments by answering that the reality is you need to know who you're settling with. You need to know who you're negotiating with. The very disclosure that there is a third-party entity who has any operational control or benefit should be discoverable, but currently often isn't. So you might be talking to someone, you might be in litigation with somebody, but you don't know. And as I'm sure the professor knows, the fact is that mandatory arbitration and mediation and conferences often go on time and time again, and they are simply a waste of money if the people who show up are in no position to do anything other than burn your money. So there are many reasons for it, but I will comment, if I don't mind, on the idea that one is discoverable and one isn't. The depth of a pocket for defense when it's insured is in fact always discovered. The depth of the ability to pay is always discovered. That sounds great, except you haven't been convicted of anything. It happens at the front end of it, and at that point you have no idea. We're not talking about how deep the pockets are. We're talking about who the pockets are. And I appreciate the gentleman yielding.
Yield back.
Delegate from Washington.
Thank you. I'd like to speak in support of Mr. Massey's amendment, because I think that this is one of those situations where we've got people on both sides who are concerned about the enormous amount of money and leverage that these giant corporations have in these lawsuits, and the amount of power that this legislation as originally drafted would give to those entities. And I'm confused, frankly, by the changing nature of even what this legislation is supposed to accomplish. Because originally I thought it was supposed to be about these foreign funders who were, you know, and I think Mr. Massey's amendment narrows it substantially to say, all right, if that's the problem we're supposed to be addressing, then let's address that problem. But now it seems that we're coming back to a whole set of other arguments about the legal system being skewed. If it's skewed in favor of those giant corporations. There are so many little guys who never get a shot at even getting to court. They don't have the money to get to court. There's no way they can even think about it. And so if you were to analyze the amount of money in the system right now, it's skewed towards the big guys. And I think the concern and the reason that there is both support from both parties on this against the original piece of legislation is because we have similar views that right now the system is being utilized, supported, funded by those giant corporations. This bill in its original form would just give more tools to those big guys. And Mr. Issa, I'm sorry, I don't know that there's going to be any weight at which the fat cats are going to get lean enough that we would want to support this, because they're really huge right now. And I think that this amendment from Mr. Massey is actually
They are small businesses. They're actually in Congressman Guerrero's in his district. So we see them every day.
I appreciate the offer. I would say that for every one of those examples, I guarantee you that the vast majority of examples that we find are not those examples. And listen, this happens where somebody will find a small business. I'm not saying that's never the case. I'm sure that's the case. But the vast majority of money right now is coming from the giant corporations, and the vast majority of people who would be benefited by the bill are the big guys. And I think we need to be looking at legislation in terms of what the effect is going to be on the entire system that already discourages the little guy from even getting into court. I mean, that's a very difficult thing to even get into court and have the money. Looks like the ranking member would like, looking so thoughtful.
I've got a question for you, if that's all right, if you deal.
Yeah.
What's odd about this legislation is that the rhetoric goes a lot further than the actual measure. So if you take what our friends are saying seriously, like the gentleman from Wisconsin, there's something illegitimate about having third-party funding at all. Well, then why not just try and ban it? Mm-hmm. Why not prohibit it if there's something wrong with it? But if there's not something wrong with it, if I've got a right to take out a loan from whomever I want, or to get money from whatever source I want to, if that's a right as a U.S. citizen to do it, to go to court, then leave us alone and stop harassing us, because that's what it is. It's basically big business harassment of little people trying to get into the legal system.
I completely agree with the ranking member, and I think that we're getting at some of the crux of the problem in the system as it stands today. I yield back.
Yield back. The gentleman from California is recognized.
Thank you, Mr. Chair. I think there's definitely truth on both sides of the argument here. I'm not sure I fully buy the image of David versus Goliath on one side or the fat cats on the other side. I think it is true that this bill would crack down on abuses. Well, it's also true that it would likely deter or chill meritorious litigation. I think it's true that the bill could level the playing field when it comes to disclosure, while also potentially further unleveling the playing field when it comes to resources. So just listening to the debate, it's pretty clear to me that this will not have the votes to pass on the floor, let alone get to 60 in the Senate. So if we actually want to make policy here, and this is a complicated policy, there's all kinds of exceptions and exceptions to the exceptions and so forth, why not narrow it to that class of cases that we can all agree are the most concerning, those where you have foreign influence involved, and see how the policy plays out there, and then we could revisit it in the future. I'd be happy to yield to Mr. Issa, Mr. Fielder, or anyone else.
Well, the amendment as it is, doesn't say how you discover that. Are you considering that this amendment by Mr. Massey should be changed to allow for in-depth discovery? Because if I can't know that the third-party funder is, in fact, when I go up the chain, the Chinese Communist government, I'm not going to find out by simply the U.S. company saying, I'm a U.S. person, and that ends it. So even if we were to go with narrowing it the way Mr. Massey is saying, all cases would have to essentially come to the judge in camera to try to figure out, does it have that element? And then the question is, how would you do further discovery? Many of the things, and I want to thank you and take you at your word that perhaps there is a narrowing, but perhaps the narrowing is that if the defendant has sales less than $100 million or a net worth of less than $10 million, they would be entitled to this information, because at that point, they'd be pretty slim. But it sounds like the people on the other side don't think that I'm thin enough or that I'll ever be thin enough. And I'm quite frankly pretty happy where I am. I don't think I want to get any thinner. The reality is that this did start off concerned about intellectual property. And if I could write the bill in the narrowest way, I would say it only concerns patent and intellectual property related cases. But to be honest, Mr. Massey objects to that and doesn't really give a darn about the rest of it by comparison. So it isn't going to change the fact that We have narrowed this to an in-camera review by a federal judge, and it need go no further if the judge sees no need for it to be disclosed further. And quite frankly, I don't know how you narrow any more than simply saying we trust a nonpartisan lifetime appointment judge to simply look and say, is there a reason particularly to affect the protective orders as to who gets information when there is a third-party profit and loss participant who might even be a competitor? Thank you, gentlemen.
I yield to the gentleman from Kentucky.
I think the gentleman from California, if Mr. Issa wants to narrow my amendment, I'm open to language to do that. I think it's sort of problematic. You might let the cat out of the bag in the very beginning when you try to, if you put very specific things in there of how you're going to find out if there's foreign interest or not. But I'm sure there's a way to do it. And I'm sure there's a way to limit the in-camera review. I have another amendment to your bill because I've got some concerns about the in-camera review. We may or may not get to that today. But if you have any ideas, I'm open to how we make sure that the bill is limited only to foreign entities.
Thomas, if I can ask you, if we did that, would you vote for this bill?
I would consider it. I would.
In other words, you're not saying you'd vote for the bill.
Well, I want to see what your fix is to do that.
If this amendment were passed, would you vote for the bill?
I would consider it.
I rest my case. I thank the gentleman for yielding.
I yield back.
Gentleman yields back. The gentlelady from California.
Thank you, Mr. Chair. I would be supporting this amendment because I agree with some of the discussion that I've heard. This is a very serious issue that actually warrants a longer discussion because this is a problem that we all face within this legal system. I mean, at the end of the day, I hope what everyone wants is that regardless of who you are, if you are harmed, you should be able to go to court, plead your case, the merits of the case should be listened to, and you should be able to prevail if the merits stand. And it shouldn't be about how much money you have. And I just don't understand why our colleagues are so upset that plaintiffs are now kind of doing what they need to do to figure out how to get the financing they need to at least give them a shot at justice in the courtroom. At the end of the day, it is about leveling the playing field so that the little guy does have a chance. Now, we keep talking about foreign money and foreign influence, and you know, I mean, we should also have a deeper conversation about that because there's actually a lot of foreign dollars that are already tilting the scales to the side of these big corporations because there are sovereign wealth funds, there are foreign investments and investors that are putting their money in these big corporations. And that's how they're able to beef up their infrastructure. That's how they're able to beef up their legal arsenal. That's how they're able to continue to snuff out the little guys. So the foreign money, I don't know about the black money, but the foreign money is already making its way through this system. Trust me. The big companies are like, how do I get bigger? Okay, monopoly time. Okay, how can I do this? Okay, foreign investments. Okay, they're trying to get a profit. Okay, they're going to get bigger and turn into a Pac-Man. Okay, little person, you're screwed. So why don't we jump way down the rabbit hole and unpack all of it so that we can try to do what many folks say, but not many folks do, which is stand up for the little person so that they feel like the courtroom is as open to them as it is to the person walking in with the silk stockings and the tassels and the gold briefcase and all that. Because I don't know, when you are hurt because you're making some quartz countertop for some rich guy who's buying their 5th home, when you are hurt because you're not getting the disclosures you need and you're taking some medicine that's hurting you, in a hospital or the doctor's not trying to help you. When you are hurt, when you go into the store and something bad happens and they just throw you out and try to like weigh you down with all of their lawyers so that you walk away, that's not helping David. That's not helping the little guy. That's not helping most of the constituents that we represent that live in our district. So I do support this amendment, and I think we should actually have a deeper conversation about third-party financing, and I think we should also have a conversation about foreign influence and foreign dollars that are already in the system, making these big corporations even bigger. Even bigger. And with that, yes, I would like to yield to the ranking member.
Thank you very kindly. I just wanted to add to the gentlelady's comments a point in response to the distinguished gentleman from California, Mr. Kiley, who makes the eminently reasonable suggestion, given the intense controversy this bill has created, why not go with the narrowest basis for the bill, the one that was originally promoted to everybody as the basis for it, which was to repel foreign influence. And the answer that we got from the gentleman from California is, well, it would be too inscrutable and indeterminate to figure out who actually was a natural person, who actually is an entity organized by the United States. But in fact, if you look at the grammar of the amendment offered by the gentleman from Kentucky, all of this comes within the discretion of the party, which has the new obligation to disclose in writing to the court all other named parties, the civil action that has a legal right to receive any payment. So they would be the ones to say, except where it's a natural person. That's not complicated at all. That makes it very simple. Thank you, and I yield back.
Gentlelady yields back. Question, we got a
Move to strike the last word.
gentleman from New York's recognized.
I will not take my full 5 minutes, but the pretty clear divide that I think we're trying to get at here is a debate between making sure we have access to courts, making sure that there is an ability to redress situations, which requires some evening out of the system so that large corporations cannot bludgeon plaintiffs to death with discovery, with motions, et cetera. On the flip side, I do understand Mr. Ice's concern that if we are dealing with trade secrets, intellectual property, and you have an unidentified foreign investor, potentially a competitor, potentially someone who can use those trade secrets with something else, that's a concern. But this doesn't address the direct balance here in a meaningful way. And I could be wrong, but I think that's what Mr. Kiley was trying to get at here, is that there is a way of enabling plaintiffs to get access to court and to be able to adjudicate their claims with third-party support, to put up some of that money that is necessary to combat the massive amounts of money from the defendants. That's an important thing. That's very important in terms of just access to courts. If you have a third-party litigator, and separate and apart from the discovery aspect of it, you are ultimately going before a judge who is going to make the decision as to whether or not there's a legitimate claim. Now, Mr. Ice is concerned about small businesses getting pummeled with, with lawsuits that they can't afford. They have to do a nuisance settlement that they can't afford. Legitimate concern, but this is not the way to solve that. We can do serious tort reform so that there are more serious penalties for frivolous lawsuits or for overreaching.
Will the gentleman yield?
Yes, of course.
Well, and I wonder, given your experience, whether you would agree also that lawyers have a professional responsibility to represent their clients and not some third party. And so there's a duty of honesty and candor before the court if somebody's actually representing somebody who's not a plaintiff in the case.
Well, of course, I think, yes, obviously the plaintiff is the plaintiff, and if somebody wants to invest in that claim, that is not the client. And I think what this ultimately goes to is that corporations don't like the fact that plaintiffs may level the playing field in terms of finances. I mean, that's just simply what the opposition to third-party litigation is that corporations, large defendants, feel like they have the upper hand, and they don't want to give that up. I agree with my colleague from Washington that for every small business that has to deal with multiple nuisance suits, I'm sure there are exponentially more small plaintiffs who get run out of court. But this just, I know we worked on this and we postponed it, but there is something here that we can agree on. But it has to include access to courts in a meaningful way while protecting our national security. And that's why I do support the amendment, but by ultimately the way that this is written makes it impossible to do that. And I'll yield to Mr. Massey.
I don't think there's anything wrong at all with the wording of my amendment. If it's flawed, then so is the entire bill. Because the bill relies on the lawyers being honest to the judge. And I believe what Mr. Issa implied was, what do you do if the lawyers are lying to the judge about foreign influence? Well, the whole bill has that defect. They could lie to the judge about anything. So, and I don't think it's a defect, by the way. And I think the amendment is just fine as it's written. And I yield back, Mr. Golden.
Thank you. Yeah, that was, I was not directing my comments at you. I agree that as written, the amendment, which I support, would address the concern of U.S. citizens versus foreign entities or persons. And I yield back.
Gentleman yields back. We have 4 votes on the floor. The committee will recess for those 4 votes. And then, pardon? 8 votes on the floor, 4 bills, I guess 8 votes. 8 votes on the floor. The committee will recess and resume when the vote series is over.